Good afternoon and welcome to Changes in Labor Laws 2022-2023. What you don't know can hurt you. I'm Angela DLHA Ashley, founder and senior managing attorney at DLHA Law Group. We're a full-service business and employment law firm founded over 22 years ago with a focus on giving businesses the attention they need for almost any legal issue that arises. We have a strong team of attorneys with experience in many practice areas to provide our clients with the legal guidance they need so that they can focus on their businesses. Today, you will hear from me and two of our lead attorneys who I will introduce momentarily. The webinar should run about 45 minutes with questions and answers at the end. But it's important to note that today we are providing you with an overview of the new laws. We are not providing legal advice. To provide legal advice to you, we would need to meet with you, understand your issue and the facts, and apply the law to those facts. So please do not rely on the information in this webinar as you would legal advice. If you need legal advice, please contact a law firm such as ours. At the end of the webinar, we will have a question and answer session. You can submit questions by using the Q&A box at the bottom of the Zoom screen. Please do not use the chat box as we will be checking it. You can submit questions at any time during the webinar, but we'll be answering them at the end of the webinar. And if we do not get to your question, or if you feel you need more information, please feel free to contact us at info@dlhalaw.com. And that should be at the bottom of your screen. With that, we have a lot to cover today, so let me introduce our panelists. First, you're going to hear from Lindsay Meyer. Lindsay is our senior employment attorney at DLHA Law. She leads our employment team in providing legal advice and representation to our business clients. This advice is given to ensure legal compliance regarding both federal and state employment-related matters. Today, Lindsay will be discussing employment law updates that will impact employers starting in the coming year. Next, you will hear from Kellen Stevens. Kellen is our senior transactional attorney at DLHA Law. He formerly worked in banking and commercial lending and now leads our transactional team. His primary focus at the firm is corporate transactions and compliance, commercial agreements, estates, and sale and acquisition and succession planning for companies of all sizes. Today, Kellen will address the changing landscape of privacy laws in California, as well as providing updates on COVID-19 laws and regulations. And we have a lot to go over. So with that, let me turn it over to Lindsay.
Great. Thank you so much, Angela. Good afternoon, everyone. I'm so happy to have you all here joining us today. As Angela mentioned, I'm going to start us off by going over laws, most of which will be effective coming into this new year. I believe there's one that is actually going to be effective in 2024, but I think it's important to mention just so companies are aware of the changes that are coming very soon in the very near future. Now, first of all, I'm going to start us off by discussing expansions to various types of leave in California. First, I will be covering the CFRA leave. California Family Rights Act provides employees who are eligible and that applies to particular employers with 5 or more employees with approximately 12 weeks of leave each year. And as of right now, how the law stands, an employee that is eligible, again, meets the eligibility criteria, will be permitted to take up to 12 weeks per year of leave for caring for a child, a parent, grandparent, grandchild, sibling, spouse, or domestic partner. However, as of January 1, 2023, it will also allow employees to take this type of protected leave for a designated person. Now, what does that mean? The designated person is going to be defined for CFRA leave as any individual related by blood to the employee or whose association with the employee is the equivalent of a family relationship. The California paid sick leave, which applies to all employers, not just employers with 5 or more employees like CFRA. California paid sick leave is available and is a right of all employees and is applicable to all employers in the state of California. And they also will be adding this category of a designated person. So an employee as of January 1, 2023 will also be able to elect to use their paid sick leave if they have any available to care for a designated person. But be cautious here, because a designated person for an employee's use of sick leave, paid sick leave, is different from an employee using their unpaid CFRA leave. The designated person definition for California paid sick leave is more broad, and it is defined as a person identified by the employee at the time the employee requests paid sick days. So unlike the CFRA's definition of a designated person, this definition does not state that the individual needs to be related by blood to the employee or that their association needs to be the equivalent of a family relationship. We have some guidance already from the California Labor Commissioner, and a designated person for California paid sick leave could possibly include an employee's roommate, someone that they're dating, their next door neighbor. So really almost anyone. So it's very, very broad, but that is different than CFRA. CFRA is the designated person definition is a little bit more narrow. Again, this is a brand new addition. So if you have any questions, please reach out to your legal counsel. You want to make sure that you're not improperly denying somebody's request for leave or granting it when you may not need to. However, it's also important to note that under this expansion of CFRA leave and California paid sick leave, that under both, in 2023, employers will be able to limit an employee to designate just one designated person to use in a 12-month period. So let me give you a quick example. If an employee elects to use 6 weeks of their 12 weeks available CFRA leave, and they're going to use the first 6 weeks for a designated person, and then they want to use their remaining 6 weeks in that same year to care for their grandmother, that would be permitted. However, if an employee elects to use 6 weeks to care for designated person 1, and then they want to use in that same year the remaining 6 weeks that they have left of CFRA leave to care for designated person 2, the employer could decline to permit the employee to use the additional leave because they are allowed to limit the employee to designate one person as a designated person in that category per 12-month period. And again, I know it gets a little confusing, so if you have any questions at the end, I'm happy to go over this again. Additionally, bereavement leave in California will now be considered a protected leave of absence. Many employers already provided employees with some type of bereavement leave, whether paid or unpaid, but now this law will apply to all private employers with 5 or more employees and all public employers. So what this means for employers with 5 or more employees is that their employees may take up to 5 days of unpaid bereavement leave upon the death of a family member, and that includes a spouse, child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. It does not include a designated person. So that's not the same quite as the CFRA and paid sick leave that I just went over. The bereavement leave, again, is protected leave, and it is unpaid. It does not have to be paid, but employees are permitted to use any existing available paid leave they may have on the books, such as vacation, sick leave, etc. Also, if an employer does offer to pay for a bereavement leave, perhaps they offer 2 days of paid bereavement leave annually. If an employee is going to use 5 days, the employer would pay them 2 out of the 5 days and then permit the employee to take the other 3 days off as unpaid. Employers absolutely can require documentation to support the leave, and the leave must be completed within 3 months of the employee's family member's passing. So if an employee's family member passes away in January, but they ask to use their bereavement leave in July, the employer could deny that request because more than 3 months has passed. Also, the bereavement leave is per occurrence. It's not just limited to per year. So if an employee has a family member pass away in March and then unfortunately another in August, each time, as long as it's within the 3-month required time frame, the employee can take up to 5 days of unpaid bereavement leave. Next slide, please. Now I will cover the expansion of the California Civil Rights Department, which previously we all referred to for years and years and years and knew as the California Department of Fair Employment and Housing. This department was recently renamed this year, just a few months ago, and is now called the California Civil Rights Department. So if you hear California Department of Fair Employment and Housing, that is the previous name, and it is now California Civil Rights Department. It's going to take me a while to get used to it. But again, the name has been changed and it has been expanded, will be expanded coming into this new year. The first expansion of California's Civil Rights Department, the CRD, will be cannabis protection, and that is going to be added to the state's discrimination law, but that does not go into effect until January 1 of 2024. The second expansion I'm going to discuss does go into effect in 2023, but the cannabis protection does not go into effect until January 1 of 2024. Employers will be prohibited under this new addition from discriminating against an employee or job applicant based on a person's use of cannabis off the job and away from the workplace. Employers will still be permitted to conduct pre-employment drug testing and refuse to hire someone based on a valid pre-employment drug screening, as long as that screening does not test for non-psychoactive cannabis metabolites. Basically, that means CBD, for example, which does not produce an effect such as a change in perception or behavior on the mind or mental process of the individual. The law also does not permit an employee to possess, be impaired by, or use cannabis on the job, and it does not affect the rights or obligations of an employer to maintain a drug and alcohol-free workplace. The second update to the California Civil Rights Department is going into effect this coming year on January 1, 2023. And the amendment will make it unlawful for employers to discriminate against an employee or job applicant based on their reproductive health decision making. So what does that mean? Reproductive health decision making will include, but is not limited to, a decision by the employee to use or access a particular drug, device, product, or medical service for their reproductive health. And with that concludes my coverage of the expansions going on regarding the various types of leave and to the CRD. And I will now return the floor to my colleague, Kellen Stevens. Thank you.
Okay. Excuse me. Hi, everyone. Thank you, Lindsay. And what I'm going to be talking about today is the California, two topics. The first one is the California Privacy Rights Act, known as the CPRA. So just a little background here. Privacy regulation has greatly expanded around the world, in Europe, and now in different states in the US, specifically in California. So in 2018, California passed the California Consumer Privacy Act, which sought to protect consumer private data. And then California's through ballot initiative passed the California Privacy Rights Act in 2020, which amended and expanded on the CCPA, clarified different aspects, increased obligations. So generally speaking, both of these grant California residents certain rights regarding their personal information and impose various data protection duties on businesses collecting or handling California residents' personal information. So beginning on January 1st, 2023, the CPRA effectively replaces the legacy CCPA. And what I'm going to focus on in that specific change is how it affects employers and employees. So the first thing to note is not every employer is included in this. You have to be a covered business. So a covered business is you have $25 million in gross revenue for the prior year. Now you got that there's a look back period. So if you close the books, see how much your gross revenue was, and then you have to come into compliance by the next calendar year. So there's some time. You buy, share, the second criteria is you buy, share, receive, or sell personal information of more than 100,000 consumers or households. That's alone or in combination. So this is one, it was actually 50,000 under the CCPA. Now it's changed to 100,000, I think with public comment. So that is something that, even though it's a high threshold, businesses, as they run through and look at the data that they collect and the different people, that they might meet that threshold. And then the last is whenever a company derives 50% of its revenue from selling consumer personal information. So those are the three ways that you can become a covered business. And what the changes for 2023, what they include are the CPRA expands employer, there we go, thanks Tim, obligations for consumers to also include handling workforce or employee data, and also business to business related personal information. So when the CPRA goes into effect, covered employees will be, employers will be able to, required to provide employees privacy notices. They will have to respond to data requests. They will have to limit uses and disclosures per employee directions. And they'll have to obtain specific contractual commitments from third parties that receive the personal information of the employees. I'm speaking broadly here because there are a lot of caveats, and there's a lot of qualifications related to business purpose or purpose for the data. And I just feel like that's too granular to get into now, but just so you know that those are considerations. So what does a business do? What's the recommendation? So what a lot of businesses and what we kind of recommend is essentially creating a data map. And that's an understanding of how your business collects, obtains, uses, stores, shares, and sells personal information. That, in one way, you want to find out whether you meet the cap if you're a covered business, but then after that, you have to find out, well, where does this information go? And one of the things that you also have to know about that information is it personal information or is it sensitive personal information? Those are two new categories that are part of the CPRA that is fully in effect on 1/1/23. Each of those have different criteria and obligations for the business. On the one hand, personal information is just something that's associated with a person or a household. And then sensitive personal information is like a social security number, driver's license number, login credentials, or personal characteristics like race, ethnicity, religious affiliation, or union membership. So it's this whole data mapping. It's important because you have to focus on where we hold this information, what we do with it, and then what that information actually is. Where in that criteria is it? So employees, like I said, they can not only request your data, they can also, well, when they request what's disclosed or collected, companies have to provide a written response to that. Employees can have that deleted or corrected, which can be a good idea. If it's inaccurate, they can also tell companies not to share the information, which happens, or generally limit the use of sensitive personal information, but with the caveat that there are reasonable parameters, purpose-driven parameters. So companies do have a limited time to respond to a request, and they must properly document all the requests. So if you receive a request from an employee about data, you have to figure out, does this actually apply to me? Am I a covered employer? Is this employee covered? And you can consult with legal counsel to make that determination. If you do respond to them, you want to show your work, put it in writing, acknowledge the request, and then talk to an attorney, because even if you're complying with the spirit of the law, which I think is probably most important in enforcement mechanisms, there's still the possibility that you're not complying technically, and that's where the attorney can come in to help you. Companies also have a limited time to respond to these requests, so it's very important to properly document that you have responded. Finally, with respect to employers, they also have to provide notice of employees' rights under the CPRA, and then kind of give them a way to tell employees how to exercise their rights. So, the notices can be drafted by counsel for your companies. Like I said, the responses to data requests can be drafted by counsel. And then if you are one of the covered businesses, then you do have to go through this full-scale review of what policies do we need? What procedures do we need? How do we comply with them? Are these reasonable? How do we ensure that they're carried forward across departments and between people and with our third-party vendors? It's a Herculean task, and it's something that is clearly huge change and in a response to a very like invasive data environment from a lot of companies that, every time we log on to a website, we give them data, they use that. Sometimes it's anonymized, sometimes it's not. And then that's sold on these tertiary markets. This is California trying to control that new information digital age, or the second maybe digital age. And they've created these laws to do that. The enforcement, well, not just the enforcement, but the agency that's tasked with like managing this mountain of regulation is the California Privacy Protection Agency. They'll update or issue new regulations regarding notices. So it is important to check in periodically to see what's changed with them. And then just if you are that covered business, you really have to come up with a game plan and take the time to make sure that you are doing your best and have consulted with the right professionals to create a compliance program for the CPRA. Okay, with privacy done, I'd just like to move on to the COVID updates. There are a few, just 3 in particular that I just thought businesses should be aware of. So the first one is AB 152. If you might recall, California had COVID-19 supplemental paid sick leave. It was potentially 80 hours of sick leave that expired on September 30th. That's been extended to December 31st. Employees do not get extra hours, but if they have any left in the bank, they can use it in this 4th quarter. Also, if they're using this leave at the end of the year and it carries over into January, they can continue to stay on the leave only to the extent that they still have hours in the bank. If they use up their time, then they're going to have to go to sick, time off, vacation, something like that. So good idea for employers, just track, as always with sick leave, with paid leave. If there's the supplemental COVID supplemental paid sick leave, track that. They get, how many hours do they get? How many do they have left? Is it going to extend or is it not? Just so that you know what you should be providing to your employees. Okay, so next is AB 2693. I actually thought that this was going to be a good change for employers because it allowed you to post in a prominent place in the workplace a notice that there was an exposure with the right information. Where was it, the location, the confirmed cases, things, relevant information, which was easier than perhaps, finding writing individual emails or notices to employees. So you could use this. AB 2693 allows this prominent posting in the workplace. However, Cal OSHA still has these emergency temporary standards that require a written notice to the employees themselves. So really, you would, if you do the public notice, you still have to do the private notice. So you're just doubling your work. My hope is that maybe Cal OSHA will lessen or change their emergency temporary standards and just rely on this new measure that passed. But in the meantime, it's probably best just to continue writing to people individually. Okay, and finally, workers' comp, AB 1751. So if you weren't aware, if there was death or injury that occurred because someone had COVID-19, there was a rebuttable presumption that they got the contagion from work. And so because of that, they were able to use workers' compensation coverage. Now, that was actually set to expire, so you couldn't presume that it was from there. The employee would have to prove that they got it at work, but that has been extended, and it's been extended until January 1st, 2024. So if someone has COVID-19, dies from it, or is injured from it to the extent that they're requesting workers' compensation coverage, there's a rebuttable presumption that it did happen at work. Okay, so those are my COVID updates, and now I'm going to hand it back to Lindsay, who's going to continue our webinar. Thank you.
Great. Thank you so much, Kellen. That segues very nicely into my next topic, which is, next slide, please. Thank you. Workplace safety. Effective this coming year, January 1, the labor code has been updated, and it prohibits employers now from taking or threatening adverse action against any employee for refusing to report to work or for leaving work because the employee has a reasonable belief that the workplace is unsafe in the event of an emergency condition. Now, emergency condition, what does that mean? The definition for that is the existence of either conditions of disaster or extreme peril to the safety of a person or property at the workplace that's caused by either natural forces or criminal act, or an order to evacuate a workplace, a worker's home, or the school of a worker's child due to, again, natural disaster or a criminal act. However, this definition of emergency condition specifically excludes a health pandemic. So the COVID-19 at this point, thankfully things are improving, but it is not included within the definition. It wouldn't be covered by emergency condition at this point. The statute does not obviously apply to certain specified workers, including but not limited to first responders and employees who provide direct patient care at a healthcare facility. Additionally, this update to the Labor Code prohibits employers from preventing their employees from accessing their cell phones or any other communication device for seeking any type of emergency assistance or for assessing the safety of a situation or otherwise communicating with a person to verify their safety. Employers are obviously permitted, when feasible, to request employees notify them if they're not going to be coming into work or leaving work, but that is only if it's feasible. These provisions are not intended to apply when an emergency condition poses an imminent threat of harm to an individual. Next slide, please. Changing topics to pay, there's a couple items to discuss here that are going to be in effect this coming year of 2023. First and foremost, pay data reporting will be covered, and then I'll move into this pay scale transparency. California recently passed laws in an effort to bolster pay transparency and counter workplace discrimination. And this transparency regarding pay is aligning California now with other states that have taken this step, which include New York, Nevada, and Washington. So effective this coming year in January 1, the law will expand the annual pay data reporting requirements on employers and to require covered employers to disclose pay scales to employees and job applicants. Now, first regarding the annual pay data reporting. Previously, California private employers with 100 or more employees were required to report pay and hours worked data by establishment, job category, sex, race, and ethnicity to what was previously known as the Fair Employment and Housing Department, now known as the California Civil Rights Department. This is still in place. However, for this update, the recent change is employers with 100 or more employees also include employers who may have 100 or more employees through a labor contractor, meaning a staffing agency. So those employers also are now covered and must adhere to this pay data reporting requirement. The law defines a labor contractor or staffing agency as an individual or entity that supplies, either with or without a contract, a client employer with workers to perform labor within the employer's usual course of business. So if your workers fall within that category of being provided by a labor contractor or staffing agency, this pay data reporting requirement will now also apply to you. Employers can still be covered by this, even if not all 100 of their employees are located inside California. So employees located inside and outside of California are counted when determining whether an employer has 100 or more employees. So if an employer has 50 employees that work inside California and 50 that work outside of California during the reporting year, they will be required to submit a pay data report to the CRD. An employer with no employees in California during the reporting year would not be required to provide the pay data report. Part-time employees also are counted the same as full-time employees. So if there's 40 part-time employees and 60 full-time employees, again, the pay data reporting requirement will be applicable to the employer. In addition to reporting the number of employees by race, ethnicity, and sex by job categories and pay bands, California employers must also now report the median and mean hourly rate within each job category for each combination of race, ethnicity, and sex in the report. Also, employers with multiple establishments are required to submit separate reports for each establishment instead of a consolidated report. So it is a lot on the employer now, a lot of extra work with this updated pay data requirement. Generally, these reports are due the following year around the end of March, 1st of April. So you want to double check with the California Civil Rights Department for the deadline for this upcoming year. And it's very important to comply because employers who fail to submit the required report to the CRD can be subject to pay costs associated with compelling their compliance. And a court could also impose penalties on the employer of up to $100 per employee and up to $200 per employee for subsequent failures for the employer's failure to file the pay data report. So again, it's very important to comply with. It is a little complicated, so if you need assistance, please reach out to your legal counsel. Our firm could certainly help you with that. In addition to this expansion, employers are now also going to be required to be more transparent regarding pay scales. As of the first of this coming year, covered employers, which include employers with 15 or more employees, must include the pay scale in all job postings. And this is now covered under the labor code for California. Pay scale is defined as the salary or hourly wage range that the employer reasonably expects to pay for the particular position. Also, if a covered employer is making a job post or listing using a third party, the employer must provide that pay scale information to the third party for it to include in the job posting. And lastly, upon request, covered employers must provide the pay scale information to their current employees as well as job applicants. And again, if an employer fails to comply with a disclosure, an aggrieved employee can file a complaint against the employer with the California Labor Commissioner within 1 year after the violation. And if the Labor Commissioner finds the employer did violate the law, the employer could be subject to pay civil penalties that can range anywhere from $100 to $10,000 per violation based on the totality of the circumstances. So again, it's very important to comply with these new with the pay data reporting as well as this new pay transparency law. And if you have any questions, please reach out to legal counsel to ensure you understand the change and your requirements as the employer. Now moving on to discuss California minimum wage in 2023. This is a new change. Previously, the minimum wage in California was separated based on small business versus larger business. The small was considered 25 or less employees, and the larger was 26 or more employees. They had different rates for minimum wage. Now, as of January 1, 2023, the minimum wage will increase to $15.50 an hour for all employers, regardless of the number of workers employed by the employer. But it's very important to note that depending on the city that your employees are working in, there could be ordinances in which have put in place a minimum wage that exceeds the state minimum wage. And some of those major cities already include Alameda, Berkeley, Los Angeles, as well as West Hollywood, Palo Alto, Richmond, San Francisco, and many more. So it's very critical to check the city that your employees are working out of to ensure that the minimum wage rate is either $15.50 or potentially it could be higher. You want to make sure that you're paying the correct amount. And it can get confusing if you have employees working out of different areas. So please double check that for this coming year. And lastly, I would like to touch on an area that has really impacted a lot of our clients. We've been getting so many calls about ADA compliance for company websites. Employers absolutely have to look out for this. I'm sure many of you have already, the past 20 years or so, employers have been already having to struggle with complying with their physical locations, making sure there's plenty of accessible parking, that ramps are a certain height, etc. And now websites, they're being attacked on websites as well, failing to be ADA compliant. So what's happening is there's a lot of plaintiffs, and they'll go out, just as plaintiffs who used to go out to physical locations, now plaintiffs who are low vision or blind, they will go and research websites to see if they can access the website using their particular software for low vision. And if a particular business website does not function with their software, they will likely bring a claim against that company, and they absolutely have a right to. Generally, like website compliance is covered by the ADA. However, there was a recent decision by the California Court of Appeals and determining that online only businesses are not considered public accommodations that are covered under the ADA. In that particular case, so that was actually a huge win for businesses. But in that particular case, a blind plaintiff had brought an ADA action against a company, claiming that he was unable to use his screen reading software to navigate a website for an online only cleaning supply company. And the court ultimately held that that particular company was not a place of public accommodation under the ADA because it had no physical presence, because it was an online only company. So again, there is some case law now that's working towards helping protect businesses from these types of lawsuits. But again, it's still a valid type of claim that can be brought against your company. You want to avoid this, and you can. There's a lot of accessibility tools out there that are free or may have an annual fee, but they will help make your website ADA compliant and able to be accessed by those who have low vision or are blind. The violations can get hefty. I believe it's approximately $4,000 per violation plus attorney's fees for each violation. So again, it's something that you want to look into. If you do not have an accessibility tool or widget already downloaded on your website, you're going to want to check with your IT staff and your legal counsel and have them work together to make sure that all the various areas of the ADA are met, so your website is compliant and you're protecting yourself from receiving one of these demands against your company. And with that, I will go ahead and turn it back over to Angela. Thank you very much.
Thank you both very much. So thank you all again for joining us. At this point, we're going to entertain some questions that have come up. The first question is, I thought the COVID pay extended through 12/31/22 was for employers with 26 or more employees. Is this correct? And that one I will give to Kellen. Kellen, and you're on mute.
Sure. Thank you very much, Angela. That's absolutely correct. It is 26 or more employees. And I realized, like, after I'd mentioned that, that was in my notes and I left it out. So thank you for correcting or for adding that. It is 26 or more employees for that COVID leave.
Okay, thank you. The next question is, do employees receive new bereavement leave if another family member passes away in the same year? And that one I will give to Lindsay.
Great, thank you. So as far as bereavement leave, your company can have its own policy as far as providing paid leave, but under California law, per occurrence, an employee is entitled to up to 5 days of unpaid leave. So it's not limited to a 12-month period. If an employee has a family member that's covered by the bereavement leave law that passes away, they can take 5 days per each time they have a family member pass away. They're not limited. So theoretically, someone could have a family member pass away in January, February, and March, and they would be entitled to take up to 5 days of unpaid protected leave in January for the passing of their family member, and then again in February for the passing of their next family member, and then another 5 days in March. So they're not limited. But if your company does have a policy where they provide 2 days of paid bereavement leave per year, that employee would only get to use 2 days. So if they had 3 family members pass away, they would only get 2 days for the first family member that passed away of paid leave, and then the rest of it would be unpaid unless they had available vacation or paid sick leave to use, which they would be permitted to use.
Okay, got it. Thank you so much, Lindsay. Next question, are the privacy rules going to start including smaller businesses in the future? And that one I will have Kellen answer, please.
Sure. You know, it's hard to make predictions. What we do know is that the covered businesses, the rules for what a covered business is in gross revenue has remained the same, but for the processing of data, the unique households or users, that actually, like I said, doubled from 50,000 to 100,000. So the public policy of protecting consumer and to an extent really just, well, not, you know, I say consumer, I say employee, it's really just California residents. It's protecting their data. And that public policy comes against just the burden of like logistical burden of actually implementing these laws for small employers. Not every employer can hire a law firm and spend the money that it takes to design a program to comply with the laws and follow through with all the changes in the laws and constantly update that and secure data and create the separate private contracts. You know, I've seen this with large employers and large clients where we have giant data privacy addendums to contracts and agreements that we thoroughly vet and talk about, okay, well, you're going to be taking care of this and this is a reasonable risk, but we have to make sure that it complies with these rules in Europe and these rules here in California. Are you working in New York or Boston or I'm sorry, Massachusetts? They have their own. And so it's very comprehensive. And I think that it's a lot to ask for a small business. So I think that they probably won't try to include smaller businesses until the technology changes to a point where it's easier to implement the solutions, because otherwise you're just going to have a law that no one can follow and that it's not really enforceable. So I would say probably not in the near future.
Okay, thank you. Interesting. Okay. We're coming up on the 12:45 hour, so let me do one or two more. How do I stay up to date on the California privacy rights rules for my business? And that one I'll give to Kellen as well.
How do you stay up to date? So I think that it's hard to stay up to date as not a practicing legal professional, to be honest with you. There are there's so much breadth in the law and what it requires that you really do have to talk to a professional. There's people that focus on this specifically. You know, there's law firms that have privacy departments, and then lawyers like us that just work generally with businesses. So we have to develop our own expertise in these areas and to help our clients. So I do think that you need to seek professional guidance and, you know, following that's the California Privacy Rights Agency. You know, they do post some notices or not so much the notices, but what's required, like kind of updates, but they don't really tell you how to execute that or effectuate it. And so that's where you have to bring in the professional, unfortunately, which is why they kind of have that high threshold for revenue or for the data. So you do need them, and especially to also, you know, maybe not just design the program, but to make sure that it's that it accomplishes its goal, that it's reasonable, that it works, and that you can year by year and like test it and make sure, okay, is what we said what we said we're going to do, are we actually doing that? Like, it's kind of like the audit of the program, and that's really big. That's really a big part that's embedded in the rules and regulations.
Okay, great, thank you. So, being true to what I said in the beginning, it's 12:45. We've hit the time to close out our webinar, but we welcome your comments or questions. And if you need any information, please do reach out to us and email us directly at info@DLHALaw.com. Thank you so much for taking the time to join us today, spend your afternoon with us and learn a little bit more about the new laws. Please join us for future webinars. We send updates regularly and we'll invite you. Have a good day and enjoy the rest of your week. Thanks so much for joining us.